This is a real courtroom interface from China. The figure in the robe is not a person. It is an AI avatar built to guide online hearings, ask parties for documents, and move cases through the system from a screen. Interfaces like this have processed real disputes for years. Meanwhile, the world's most famous robot judge, the one Estonia supposedly built to decide small claims, never existed at all. The avatar does not deliver verdicts. It handles procedure, checking filings, guiding litigants, scheduling, routing. Anything contested goes to a human judge. Nearly every real system in the world today sits on that same line. Machines run the process, humans make the call. The open question is how far that line can move. Picture it as a ladder with 4 rungs. On the bottom rung, AI runs court plumbing: transcription, filing, search, scheduling. One rung up, it assists judges: research, summaries, similar past cases. On the 3rd rung, it starts deciding: small, structured disputes with a human appeal behind it. And the top rung is full replacement: an AI that hears your case and rules on your life. The first 2 rungs exist now. The 3rd is being tested. The 4th is where the fight begins. Start with the myth, because it shaped everything. In 2019, a wave of headlines announced that Estonia was building a robot judge to rule on small claims worth up to about 7,000 euros. The story fit perfectly. The most digital country in Europe, automating justice itself. It spread for 3 years. Then, Estonia's Ministry of Justice published a correction. There was no robot judge project, no plan to replace human judges, and the famous article was misleading. The most cited AI judge on Earth was a misunderstanding. What Estonia actually built is less cinematic and more instructive. Its courts digitize the paperwork around judging: electronic filing, machine transcription of hearings, automated anonymization of published decisions, and streamlined payment orders for debts nobody disputes. Its judicial plans through 2030 describe AI as an aid: case management, research, drafting, with the judge still deciding. Estonia automated the queue, not the verdict. The myth still did real damage. A justice system runs on the belief that decisions are made fairly, by someone who can be questioned. If the public cannot tell what a court's software actually does, that belief starts eroding before any system is switched on. China is the opposite case. Less myth, more machinery. In 2017, Hangzhou opened the country's first internet court, followed by Beijing and Guangzhou. These are real courts for online disputes: e-commerce, copyright, digital contracts. You file from a phone, appear by video, and submit evidence sealed with timestamps and blockchain verification. Reports from these courts claim hearings that once filled an afternoon now finish in a fraction of the time. Then it's scaled. In late 2024, China's Supreme People's Court unveiled a national legal AI platform trained on hundreds of millions of judicial documents. It reads case files, extracts the key points, retrieves similar past rulings, and drafts. Some courts already use software that computes sentencing recommendations from checkboxes and formulas: a base sentence, adjustments, a suggested range. A human judge still signs every decision, but when the system recommends the number, the signature starts to look like the final step in someone else's calculation. The United States ran into that exact problem years before chatbots. For years, many American courts have used risk assessment algorithms that score how likely a defendant is to reoffend, and judges see those scores at bail and sentencing. In 2016, Wisconsin's highest court allowed a proprietary score called Compass to stay in a sentencing decision, even though the defendant could not examine how it worked. That same year, journalists analyzed thousands of Compass scores and reported that black defendants were more likely than white defendants to be wrongly flagged as high risk. The company replied that its scores were equally accurate across races. Both claims can be true at once. Fairness has several mathematical definitions, and they can contradict each other.
Now, generative AI has reached the judges themselves. In a 2026 survey of federal judges, more than 60% of those responding said they had used an AI tool in their work, mostly for legal research, though fewer than a quarter used one weekly, and almost 4 in 10 never had. At the same time, courts keep catching fabricated citations, briefs quoting cases that do not exist, and reported instances of AI-linked errors appearing in court orders themselves. Judges have sanctioned lawyers over it, and senators have demanded that the judiciary write formal rules.
The Chief Justice of the United States put the institutional worry plainly in a year-end report. AI could widen access to legal information, but it demands caution and humility. And people consistently tell researchers they believe a human judge is fairer than a machine. Even a machine that is right more often cannot run a court for long on decisions the public refuses to accept.
So where does AI actually get to decide? Watch the third rung. In private arbitration, it has already started. In 2026, America's largest arbitration body introduced an AI arbitrator for narrow, documents-only commercial disputes. Both sides consent, the domain is tightly scoped, and humans oversee the output. Online platforms have settled shopping and payment disputes with software for years. The pattern is consistent: closed domain, structured evidence, modest stakes, and a human appeal that actually functions. Here is the honest case for letting it climb that far. Courts are slow and expensive almost everywhere, and the people they exclude first are the ones who cannot afford lawyers or years of waiting. Countless valid small claims simply die unfiled. An AI that resolves a deposit dispute in a week for a filing fee instead of a legal bill, with a human court standing behind it, that widens access to justice. Rejecting it out of reflex protects the people who could already afford the courtroom. The top rung is different in kind. A court looks like a prediction engine only from the outside. Underneath, it is a legitimacy machine. A judgment has to come with reasons the losing side can read and attack on appeal. It has to weigh things no case file captures: remorse, desperation, a first offense set against a broken life. And when it goes wrong, someone identifiable has to answer. A judge can be questioned, overruled, and removed. A model's weights cannot be cross-examined. A human reviewer on top does not fix this by itself. A reviewer who signs 300 AI drafts a day is a rubber stamp with a pulse. And scale cuts both ways. A biased human judge damages the cases in one courtroom. A biased model deployed nationwide repeats the same tilt in every courtroom at once, faster, cheaper, and wearing the confidence of mathematics. The risk score story already showed how bias can hide inside systems that look neutral. Speed makes good systems better, and bad systems catastrophic. So, can we have AI judges? We already do on the bottom rungs. Software runs court paperwork in Estonia, drafts and compares cases in China, and sits inside American judges' research tools right now. AI deciding small, structured disputes with a real human appeal is arriving through arbitration and online platforms. And, used carefully, it could reopen courts to people who gave up on them long ago. Full replacement is the rung with no good answer yet, and the obstacle was never intelligence. It is a question older than the technology. When a decision destroys someone's life, who stands up and answers for it? Until an AI can do that, the robe stays on a human.